Session is now open.
The public interview for the candidates for the position of Chief Justice of the Supreme Court of the Philippines is hereby open. The candidates to be interviewed today are the following: Dean Andres D. Bautista, Chairman of the Presidential Commission on Good Government; Attorney Soledad M. Cagampang de Castro, Consultant of Counsel of De Castro and Cagampang De Castro Law Firm; Secretary Laila M. De Lima of the Department of Justice; Dean Jose Manuel I. Jocno, Executive Director, Jocno Law Center; Solicitor General Francis H. Hardelesa; and Senior Vice President and Chief Legal Counsel, Maria Carolina Legarda of the GSIS. To be interviewed first will be Dean Andres D. Bautista. May we request him to remain and request the other candidates to leave the room while the interview of Dean Bautista is being conducted.
Congressman Tupas will join us later. Justice Hermosissima likewise will join us later. The sequence of the interview is this way. Attorney Cayusa will first ask the questions. Then Attorney Mejia will be the next. Thereafter, Justice Lagman will ask the questions. Then Justice Hermosissima. Thereafter, Congressman Tupas will ask the questions. And follow him will be Secretary Musky. And the last one is yours truly. Are you now ready, Attorney Cayusa?
Okay. Mr. Presiding Officer, good morning.
Yes, go ahead, please.
I have prepared a brief PowerPoint presentation, but if it's not possible to conduct one, I have hard copies, which I would like to provide
I
to
think it's
the
better
members
if
of the
you,
Council.
Yeah, I think it's better that you give us the hard copies because we'll maybe running short of time. No? We cannot predict how long the questioning will take. It will depend on the answers that you will be giving. So I think it would be better that you give the hard copy, Dean. Okay.
I will do that, Mr. Justice. But also, may I be, in lieu of the presentation, can I be allowed to deliver a brief opening statement?
How long will it take?
I would say not longer than 10 minutes.
Can you shorten it? Let's say 3 minutes.
I will try my best.
Okay. Now that will right? Okay. Go ahead then, Dean.
Can I occupy the podium?
You prefer to be
I think I would be more
in the middle?
comfortable
You will be more
standing
comfortable
up.
in the middle? Yeah, considering your age, probably you are more comfortable standing. Okay, go ahead then.
Thank you very much. Mr. Presiding Officer, members of the Council, being the first to be interviewed, or perhaps using law school language, being the first to be called for recitation, is both a burden and a blessing. It is a burden because at this point I have no idea what questions my JBC professors will be asking. As the youngest in the class, I was hoping to learn from, perhaps even copy from my older classmates. But being the first to recite is also a blessing because one gets the opportunity to set the tone, provide a context, and perhaps even help frame the important issues relating to these proceedings. Indeed, choosing the next Chief Justice is a defining moment for the Philippine legal system. But while the importance of this changing of the guard cannot be gainsaid, we should not lose sight of our larger objective, which is to overhaul an ineffective, inefficient, and inadequate justice system. Indeed, this process should be less about choosing one person but more about ensuring that genuine reforms are truly in place to achieve that objective. In the 2011 Global Competitiveness Report released by the World Economic Forum, the Philippines ranked the lowest among ASEAN countries in respect of the three main indicators of a functioning legal system. Back home, in the most recent SWS survey regarding public satisfaction with top government institutions, the Supreme Court's net satisfaction rating dropped by 14 points, from plus 27 in March to plus 13 in May 2012. This is the lowest rating received by the court since 2005. And the court ranked the lowest as compared to the other branches of government, the Senate, the House of Representatives, and the Cabinet. The first step in solving any problem is to recognize that there is a problem. And the opposite to the saying, if it ain't broke, why fix it, is if it's broke, then we should fix it. I believe that the Philippine legal system faces four major challenges that all begin with the letter C: corruption, congestion/delay, competence, and credibility. Hoodlums in robes, it's not whether you know the law, but whether you know the judge, are phrases mouthed not just by legal practitioners, but by non-lawyers as well. With due respect to the honest and hard-working employees in the Philippine legal system, unfortunately, you have become the exception rather than the general rule. Congestion of court dockets and delay in deciding cases are kindred problems. 25 years ago, a legal command was made as follows: the Supreme Court shall, within 1 year after the ratification of this Constitution, adopt a systematic plan to expedite the decision or resolution of cases or matters pending in the Supreme Court or the lower courts prior to the effectivity of this Constitution. This command is contained in Article 18, Section 12 of the Transitory Provisions. In this regard, the latest figures as contained in the 2010 Supreme Court Annual Report show that the average disposition rate for all the courts for the entire judiciary is 39%. In other words, more than 60% of pending cases were not decided. It is quite apparent then that what has happened to that 25-year-old constitutional directive? Not much. I shudder when I think about the financial and economic repercussions that all this delay and congestion have caused. Unlike in the US and other developed countries, where top law school graduates vie for limited judicial clerkships, in the Philippines, the beeline is with the top Makati law firms. We all know that any agency, be it in the private or the public sector, is as good as the people who are in it. Hence, there must be a concerted effort on the part of the Supreme Court to hire and keep the best and brightest lawyers within the judicial ranks. On credibility, yes, the Supreme Court has the final say on what the Constitution and other laws mean, and that we are all duty-bound to obey its rulings. But the court should never forget that it remains accountable to the people and to the higher court of public opinion. Decisions that are perceived to be manifestly wrong, obtained through political, financial, or fraternal influence, or that flip-flop, chip away at the very credibility upon which the court ultimately anchors its authority upon. It is only right that if we identify challenges, we must also proactively propose solutions. To address the issues of corruption and competence, the first thing the Supreme Court should do is to mount an aggressive campaign to recruit the best and brightest lawyers and law students. This should be done fully realizing that its work is only as good as the people who do them. Towards this end, the three branches of government should work hand in hand to improve the compensation packages, equipment and tools, and court infrastructure taking into account the workloads of judges as well as the physical and reputational risk that their position entails.
Excuse me, Dean, can you now wind up?
Okay, Mr. Justice, just a few more minutes. Let me just go then. Well, I have a slew of solutions which perhaps can be asked later, but maybe just as a final statement before I am asked questions, I would like to say that really, to maintain and enhance its credibility, the Supreme Court should lead by example. It should wipe out its own backlog. It should be more transparent and accountable in the use of public funds. It's about time that the gods of Faura realize that they are more human and less divine. Every year, it should let the public know what its goals, objectives, and key results areas are. Thereafter, it should perhaps hold its own State of the Judiciary address and report on its performance. In short, the Supreme Court should exhibit not just political but judicial will in creating a justice system that we can all be proud of. These are my initial thoughts on the challenges facing our legal system. I have a few more, but I do not wish to abuse the time given by the Council. Mr. Presiding Officer, I'm now ready for recitation.
Okay, Attorney Cayusa, you want to remain standing? Can you endure more than an hour of standing with all the questions propounded to you? Dean, will you be, this time you'll be more comfortable sitting?
No, perhaps I will just remain standing. Well, I will try to endure as best as I can, sir.
Okay. Attorney Cayusa then.
Thank you, Mr. Chairman. Before I propound my question, Mr. Chairman, may I just state for the record and disclose that I have known Chairman Bautista personally since the 1980s, when we both served under the Office of the Chief Justice, and that he was legal counsel of my father's campaign, and he is a personal friend, as I stated. Now, may I proceed with my questions. Chairman Bautista, in the recent forum, and you reiterated today, you presented the pressing need for judicial reforms. In fact, you characterize our present justice system as inefficient, ineffective, and inadequate. What have you personally accomplished in your private or career life, public career rather, particularly as PCGG chairman, that would show that you have what it takes to head the Supreme Court, lead the branch toward the much-needed reforms, and to address the problems of inefficiency, inadequacy, and ineffectiveness?
Thank you very much for that question, Attorney Cayusa. You know, in fact, I have now been with the PCGG for close to 2 years, and I can say that the problems that we encountered coming in mirror the problems that are now facing our judicial system. That when we came in, the PCGG was ineffective, it was inefficient, and it was inadequate. So what we immediately did was we had to restore the credibility of the institution, because that was a main issue, that the very integrity of its creation was being questioned. Its past performance and track record was always being scrutinized. So what we did was that, first of all, I was very fortunate that I was able to convince like-minded, like-valued, and like-principled people to join me in the crusade. And the President was kind enough to appoint them. Second, again, we had to increase transparency and accountability in the way we did things. After all, our name is the Presidential Commission on Good Government. So we had to lead by example. So towards that end, we immediately revamped our website. We came out with a 100-day report. We also came out recently with a milestone report. So we have been proactively speaking with and receiving feedback from our stakeholders, including other government agencies, coconut farmers, human rights victims, the media, and the general public. So in this respect, I think that the situation is similar, although, of course, the PCGG is a microcosm of the bigger problems involving our judicial system. One thing I would also like to say is that really when we came in, we've noticed that there are many faults that we found in the PCGG, and I must say some of these faults can be traced also to the problems of our judicial system. We still have a backlog of 276 cases, and this is after 26 years of existence. Just by way of an anecdote, we have 101 cases pending with the Sandigan Bayan. And out of those 101 cases, well, the average length of time that these cases have been pending is 20 years, with the longest being 25 years. 64% of those 101 cases are more than 20 years old. So we have issues there. We have also issues with respect to the Supreme Court insofar as our pending cases. Out of 65 cases, I think that the average period that it is pending in the Supreme Court is 9 years, and the longest being 21 years. So again, this is something that we hope that we can get some closure on, and that's why we have been filing motions for early resolution with both courts. Thank you.
Thank you, Chairman Bautista. Now, you mentioned that you would want a court that where the public will know what its goals are, so there is something to measure the performance of the court. But I think the main concern would be how you will be able to get the present members of the Supreme Court who are more senior than you are in age, who may not have the same values as you are fortunate to have in your commission among your peers, and in judicial experience, in order to support your proposals for judicial reform?
Well, I would like to think that regardless of age, lawyers have common principles, common values, common ways of sort of like seeing what is right and what is wrong. I would also like to think that the current membership of the court, even if they're older than I am, if ever they see a good thing, if ever they are exposed to fresh ideas and fresh insights, that they would be adaptable and that they would see things differently. So I've had this issue before in previous undertakings. Yes, it can be a challenge. But as I said, as long as people focus not on the personalities, but focus on the principles and the values and the work at hand, I think it is doable. Now, the one thing also I wanted to say was with respect to these goals and objectives, I was hoping that the court would run itself more like a business, in a sense that you must have work plans. You must have key result areas that you have to report on. I don't know, as you had pointed out, we started here in the Supreme Court in the 1980s. From then until now, I have not heard of any planning session or, say, strategic planning workshop that the courts would do at the beginning of the year to map out what kind of goals and objectives they would like to attain. I think this is something that they should really look into. And after that, as I said, that the time of being cloistered, that the time of being like a hermit, I think is gone, because even the Pink Sisters or the Trappist monks of Guimaras now use the internet and also text. So I think it's high time that the court open up its operations, receive constructive feedback, and I would like to emphasize the adjective constructive, from the public so that it can improve on its operations.
Moving on to another topic, you have taught constitutional law for many years. And how would you use this rule-making power of the Supreme Court under the 1987 Constitution to address issues of delay in the disposition of cases, as well as corruption in the courts?
Right. Well, actually, I did have a little paragraph on that. So let me... I think what we should do, first of all, is that we should consider the outsourcing of the management of dockets as distinguished from judicial writing to the private sector, so that the latest technology can be used to track the status of cases. That way, judicial scorecards can be developed to effectively monitor court performance. Similarly, why should court administration be assigned to lawyers when other professionals could do a better job? Now, if a lawyer had an MBA degree as well, that would be a different story. The other thing that I think that the courts should take into account, well, with respect to specific amendments, I would say that the rules of court, and specifically the rules on civil procedure and criminal procedure, should be amended so that the filing of frivolous cases and interlocutory appeals should be minimized. We all know how Rule 65 has been abused. In that regard, we also should look at Rules 41, 45, and Rule 58. There should be a limit to the motions to postpone and seek an extension of time to file a pleading. Also, judges should be encouraged to write shorter decisions and to use language that the non-lawyer parties can understand. But also, if I may say, a major culprit for delay is in the Constitution. Article 8, Section 15, Paragraph 1. This states that the period to decide cases is counted from the time a case has been submitted for decision. But it can take 5, 15, even 30 years before a case is deemed submitted for decision. So in reality, the Constitution has not arrested, but has in fact countenanced delay. The quick fix is to amend this section so that we count the period for deciding not from the date of submission, but from the date of filing. Thank you.
What about with respect to corruption? Do you have any thoughts on how the rules can be amended in order to address the problem on corruption, or do you feel that the new Code of Judicial Conduct would suffice?
If you ask me, I think that the rules are sufficient. The problem, again, is with respect to the people. After all is said and done, we have good rules. We also have good laws, but the issue is with respect to implementation. And that's why, if you ask me, what would I do? First thing, I would get good people. And when I say good people, I mean competent and honest people who could do the job. So to me, the big problem of the Supreme Court is a human resources problem. Because once you get good people, then corruption will be minimized. Obviously, we will also need the cooperation of the integrated bar and other sectors, the business sector, because it takes two parties to have a corrupt transaction. So, in the same light, they should work hand in hand with the courts so that not just real issues of corruption are prevented, but even perception. Because after all is said and done, perception can become reality. And it is important that that the people believe in the credibility and the integrity of the court system for our society to properly function.
You agree that independence is also a major factor in the courts. Now, my next question is, do you recall any specific instance where you as a public official have shown integrity and independence from the appointing power?
Yes, I do. And in fact, I hope I will not be violating confidences. But as you know, one of the big issues facing the PCGG is the COCO levy cases involving the San Miguel shares. And our commission felt that it was really our duty to try our best, even given the circumstances, to try and get back that COCO levy monies and the San Miguel shares back to the government for the benefit of the Filipino people. Because I think of our zealousness, I was called to Malacanang to make a presentation to the President and to the entire cabinet in respect of this issue. I do know that the President is related to Ambassador Cojuangco. Although I must again say that after making our presentation, the President just was nodding his head, did not provide us any instructions for or against. He just wanted to know what was going on with respect to these cases, and he has allowed us to do our job. But I must admit that it sort of like made me think twice as to how we should proceed with this matter.
Thank you, Dean Bautista. Now, may I just be allowed one more question, which I feel is quite necessary, in as much as the chairman is not only chairman of the PCGG, but also a law dean. And I also a member of the MCLE committee. What do you feel has to be done as far as continuing legal education is concerned in order to improve the moral fiber of our legal profession?
Well, first of all, I think that the moral fiber, though, will be created during the more formative years. As we all know, the older we are, the more set we can be in our ways. But having said that, with respect to legal ethics, I think the way it's being taught is wrong. It is too academic. It is too classroom-oriented. I think it has to be more real-world-like. I think that lawyers, well, law students, lawyers should be exposed to real-life situations. Ask, real-life questions. And that's how you really learn what is right and wrong. Right? Again, here, there are many cases, or there are many examples we can get from other countries. This problem of corruption is not common, or is not unique to the Philippines. Other countries have dealt with this problem, and successfully, I might add. So all we need to do, I think, is look for these best practices. We should not just copy blindly. We should know how to adopt these best practices to our own peculiar situation.
Thank you, Chairman Bautista, and
Thank
good
you.
luck.
Thank you.
Thank you, Mr. Chairman. I have no further questions.
Attorney Mejia.
Thank you, Mr. Chairman. Good morning, Dean Bautista.
Good morning, Professor.
How long have you been with the PCGG, if I may ask, for starters?
Close to 2 years. I started in September 2010.
What makes you think it's now about time to move up to the Supreme Court from your present stint as PCGG's chair?
Well, I was nominated. This was not something that I was, that was part and parcel of my career plans, Professor Mejia. There was a vacancy. I was nominated. I thought twice as to whether to accept the nomination, but I said to myself, why not do it? But as I said, not really to get appointed, but more to try and expose the issues in relation to the state of our judicial system.
One of the questions that I listed is to ask you what you think plagues our judiciary today, and apparently you have addressed that in your presentation. You may have missed out something, that some of the more salient points that will address that question. I'm giving you the opportunity to mention those things which you may have missed out given your limited time.
Thank you very much, Professor Mejia. Well, as I said, you know that the issues relating to congestion of court dockets and delay have been plaguing our legal system since time immemorial and require radical, out-of-the-box solutions. Also, as we try to increase the compensation of our judges, I think we should realize that it is not practicable to fully benchmark the compensation of our judges to that of the private sector. However, the court has the luxury of appealing to the patriotic sense of a lawyer. I remember in college, well, maybe you will, that there was this poster ad that tried to recruit Jesuit novices. And they used the tagline, "Why sell soap? Build people." I was thinking that perhaps the Supreme Court can entice law graduates with a similar tagline, such as, "Why just practice law? dispense justice. Again, this goes hand in hand, I think, with the overriding need to attract the best and the brightest to join the judiciary. If I may, again, relate to you just one short anecdote. 2 weeks ago, I asked my class of 40 students, I said, okay, ladies and gentlemen, I said, how many of you, potential lawyers, want to be judges? Out of the 40, only 2 raised their hands. And they said, I want to be, sir, but only if Supreme Court. Now, I think this was not how it was during my grandfather's time and my father's time. Being a being a judge was a position of honor. It was looked upon with with great respect. But nowadays, I get the sense, having been teaching law for over 20 years, that that is not anymore the priority of our law students. That they only go to the courts in case they don't make it in practice, which is not how it should be. As I said, for our justice system to work, it must be able to again attract the best and the brightest.
Okay, related to that incident that you just mentioned, Dean Bautista, do you think that the present law school curriculum provides sufficient training to law students who want to pursue a career in the judiciary?
Yes, it does. Although, again, I hasten to add, and now there is a change from the rigid LLB to the more flexible JD, which I think is a step in the right direction. Essentially, the two are the same, except that JD allows a law student to specialize in a practice area earlier on. So, for example, if it is really a law student's dream to be a judge or to be a litigator, he or she can focus the subjects that he or she takes to litigation-related areas. On the other hand, if you want to do corporate law or you want to do tax, then you can take subjects that are related to these areas of specialization. I think this is a step in the right direction. This is similar to what's going on in medicine. So, in terms of the curriculum, I don't think there's anything wrong, although I think we should encourage law schools to be more, to find their niches, to look for their areas of specialization, like what is happening in foreign law schools.
Why should the president appoint someone from the outside? I mean, let me be more specific. There is an apprehension that if someone is appointed from the outside to head the Supreme Court, there will be massive demoralization within the Supreme Court. How will you address that concern?
That's an excellent question, Professor Mejia. I think if you ask me, all things being equal, the next Chief Justice should be an insider rather than an outsider. And why is that? Because again, if you look at other institutions, you would like to convey the message that people can rise up the ranks. And also, you have issues in relation to experience, that somebody who has been there knows the problems and should be able to tackle these problems better. But I must say that this situation we are in is unusual, in the sense that all of a sudden there was a vacancy which was not planned. And as I said, part of the problem, if I may say, that the impeachment that happened was not, to me, just an impeachment of a person, but the impeachment of the entire judicial system. And that is where an outsider might be able to help. He or she may be able to bring a breath of fresh air, a new perspective as to how things can be done. So I said, I think that the Supreme Court should realize that there is a credibility issue that it is facing right now, and that it cannot be just business as usual. We must do ways and means in order to repair that integrity, and I hope that that choosing the Chief Justice is the first step towards that improvement.
That's my final question. Good luck, Dean Bautista, and thank you, Mr. Chair.
Thank you.
Justice Langman.
Thank you very much, Mr. Chair. Dean, is it Dean or Chairman? How do you
Kahit
like
Andy lang po, okay na.
No.
Kasi po minsan, alam nyo, isa pa yun, yung titulo.
Yes.
Dito sa atin, minsan masyadong hang up yung mga tao sa titulo.
Yes.
Ako, Andy lang po, okay lang.
You cannot avoid the fact that you are the chairman of the PCGG and a dean of a prestigious law school.
Salamat po.
So, I will call you chairman. Okay. Now, I know that you have answered the question of Attorney Cayosa regarding your age. But I feel that I still want to ask you this question. At the age of 48, if you will be appointed as the next Chief Justice, you will be serving the court in that position for 22 years, which would effectively deprive all the incumbent associates to that post. Okay, under that situation, if you will be the Chief Justice, how are you going and get the trust and confidence of the to lead the court with moral ascendancy? Okay.
Thank you for that question, Justice Lagman.
Yes.
In fact, that was one of the questions I was really hoping that somebody would ask.
Okay, thank you.
With respect to age, I think that, as we all know, age can be good or bad. And sometimes, and now you can always hear people saying that age is a state of mind. That age can be good if you have a good person who can steer the institution for a long period of time. But age can be bad if you have a bad person who is in office for a long period of time.
Yes.
But to address that particular issue, in fact, I believe that there should be judicial term limits. In the same way that there are term limits in the executive branch, there are term limits in the legislative branch. We copied this sitting until 70, or as you know, in the U.S. Constitution, it is not just 70, but until they are able to. Okay, we copied that from the U.S. Constitution, but we have to remember that at that time the U.S. Constitution was ratified in 1791. I think that the probable age of people then, their longevity was only in the 50s, and that's why they were not expected to live long. No? But to my mind, well, that one, by the way, is already being challenged. There was a recent survey in the U.S. which showed that 66% of U.S. adults believe that that should be amended and that there should also be term limits in the judiciary. So if you ask me what I would propose, we should have a 770 rule in the judiciary, meaning that term limit of only 7 years, regardless of what age, and once you reach the age of 70, then you have to retire. Okay? And as in the same way that you asked all of us candidates to sign a waiver of our bank accounts, I am also willing to sign a waiver to say that I will only serve for 7 years, if appointed.
Okay. Thank you very much, Chairman. Now, I'll go to another point. We all know that the impeachment of the former Chief Justice has affected the judiciary in a way. Now, in your opinion, what kind of a Chief Justice do we need today to regain the respect, the trust, and confidence of the people, and to restore the cordial relationships of the judiciary with the other branches of government?
I agree with you, Justice, that indeed I think that the impeachment caused a disruption in terms of how our justice system works. But I believe that this disruption is actually healthy. And to be honest, I have read papers saying that maybe we should have a healing Chief Justice at this point. I think that is not yet time. I think there continues to be problems and issues that the judiciary faces that also needs further reform. So yes, again, at some point, people should learn to disagree without being disagreeable. If people are just very professional in the way they do things, I don't think there will be a problem. Okay? And insofar as being able to ensure that the credibility is restored and maintained, to my mind, the solution is changing culture, changing attitude, and changing mindset. That the courts should be more transparent in the way they do things. They should be able to get buy-in and participation from the public. They should get the people more involved in their operation so that the people are not kept in the dark. Because I think that's part and parcel of the problem, that the Supreme Court is seen sometimes as a mystery, as as an old boys club, as secret society and things like that. The way to do it is to open it up. One of my favorite sayings is, sunlight is the best disinfectant. Open it up, let the sun shine through, and I think that the credibility of the court will be restored.
Okay, thank you very much. Now, if you will be fortunate to be nominated and appointed as the next Chief Justice, what would be your top 3 priorities upon assumption of office?
If I may reiterate, Madam Justice, first overhaul HR, human resources.
Okay.
Attract the best and the brightest. Because as I said, the work that an agency does is only as good as the people who do them. Number 2, finally fix the case congestion and delay. That to me is the biggest practical issue facing the courts. And I said, I shudder when I think about the economic repercussions of this delay. And then finally, after all is said and done, the Supreme Court should lead by example. Lead by example in terms of wiping out its own backlog, leading by example in terms of accountability and transparency, leading by example by being more should really reach out and let its hand go through and speak to the other stakeholders so that we may be able to really show what it's trying to do, and after its performance it's able to really assure the people that it is here to try and improve our justice system.
Okay. Chairman, my last question. I feel that I have to tell you this to be fair and to give you a chance to comment on this publicly. Yesterday, actually this was received by our office on July 20. A letter was filed by the Philippine Overseas Telecommunication Corporation. What is this? The PhilComSat group of companies and the PHC through their counsel, Attorney Kapunan, opposing your nomination to the position of Chief Justice. Now, they allege that your refusal to abide by the resolutions and directives of the Ombudsman, the Supreme Court, the PCGG itself, and the Department of Justice has caused irreparable damage to these corporations. Do you want to comment on this?
Yes, of course I do, Madam Justice.
Okay.
In a strange way, I welcome this opposition because it gives me again an opportunity to preach the gospel of good governance. They were saying that you're probably not doing your job in government unless a case is filed against you. So be careful what you wish for.
Yeah.
To me, it is a badge of honor if a case is filed against you wherein you are trying to protect government interest. Just by way of background, those opposing my nomination, well, Mrs. Erlinda Ilusorio Bildner is the president of PhilComSat. She is the daughter of Potenciano Ilusorio, who, according to PCGG records, was a Marcos crony. And then the lawyer who signed it, Attorney Lorna Pataho Kapunan, also, she was the daughter of a Marcos classmate, former COMELEC Commissioner and Justice Lino Pataho. One of the problems in PCGG is that you get mixed up with people from the Marcos regime. And again, most of them are back in power, and that's why it is very difficult to go against them. But just for the record, the current PCGG, okay, has, if you look at the allegations, if you look at the dates, it's all before September 2010. So we have done no wrong against PhilComSat. In fact, the funny thing is that I have been elected the chairman of POTC in September 2011, up to now. But under the bylaws, only the president and 2 members of the board can call a meeting. It is what, 10 months already? No board meeting has been called. Also, in respect of, again, we have not received a single centavo from PhilComSat or POTC. What we're all asking from the current management, okay, is that they be transparent and accountable in the way they're managing the company. The government has a 35% interest in these companies, which was surrendered to the government, to PCGG by the group of Mr. Campos. We just want to protect that interest. And that's why I challenge both Ms. Bildner and Ms. Kapunan, let's have a full-blown Senate investigation on this matter, because I would be more than willing to meet whatever opposition they may have.
Okay. Thank you very much, Chairman. That is my last question, and good luck.
Thank you.
Justice Hermosissima.
Good morning, Dean.
Good morning po, Justice.
We acknowledge the arrival of Congressman Tupas.
Thank you.
Your impeccable credentials, academic credentials have preceded you, sir.
Salamat po.
In the Supreme Court, cases are raffled to individual justices. In the Court of Appeals and the Sandigan Bayan, cases are raffled to the divisions through their respective chairmen. Which method of dispensing justice is your preference?
If you ask me, Justice, I think both are doable. Again, to me, the key is just ensuring that the rules are clear as to how the raffle is being conducted. And here you have to strike a balance between confidentiality and transparency. So you have to ensure that there is a certain sense of confidentiality so that justices and judges cannot be approached. But on the other hand, you also want to restore credibility in the system. And I think that the way to do that is to be transparent in the way you do things. So whatever be the rule, let's just make sure that people are made aware of them.
In the latter method, the chairman will have the power to farm out the cases to justices more expert on the subject at hand.
And aside from that,
however, the procedure will give rise to, or give the opportunity for graft and corruption. So, what are your thoughts on this point?
Well, graft and corruption, not necessarily. I think it makes sense that a justice who has a certain expertise should be tapped in order to write decisions on that subject area. Also, I think that the other thing we should consider is the cases that justice is handling. That we should try our best to ensure that it is evened out. You know, that so that they will not complain about workload. We should try to distribute cases in accordance also with the workload and with the area of specialization.
On another matter, presently, cases which are not necessarily decided en banc are decided by a division of the Supreme Court. The decision of the ponente in that division is considered a decision of the whole court. There are objections to the manner of deciding cases, to this manner of deciding cases, because it is felt that the decision of a division is not reflective of the sentiment of the whole court. What are your thoughts on this matter?
Well, Mr. Justice, first of all, I think this
Would
is one of...
you agree to the proposition that all cases be decided en banc instead of by division?
No, I don't agree with that, because I think that will lead to further delay and congestion into our legal system. In fact, I would also advocate perhaps a system similar to the United States, wherein the Supreme Court should be given the prerogative to choose the landmark cases that in which it wishes to take up and provide a definitive ruling on. That right now, everything needs or has to go up to the Supreme Court. And I think this is not healthy. Now, insofar as the decision of a division being a decision of the court, I think that that's the right direction. That again, why does everything have to go to the court en banc? Now, but there have been instances wherein a decision of a division has been overturned by the en banc. Perhaps in certain exceptional and meritorious cases, that should be done, but it has to be done in a very transparent and accountable way.
Well, if we have to compare the decision, the cases in the United States Supreme Court and the Philippine Supreme Court, it has been said that in this United States Supreme Court they are deciding only 100 cases per semester. But why is it that even ejectment cases go up to the Supreme Court? Why does the Supreme Court not decide only questions of law? As it is, we are deciding cases on questions of fact. If we be strict with that, then there will be a limit to the cases before the Supreme Court.
I agree with you 100%, Justice, that we should amend the rules so that these frivolous cases should no longer be brought up to the Supreme Court.
It's not really this is the rule, that only the Supreme Court decides only on questions of law. But we are deciding cases on questions of fact. Well, on another matter, since you are an expert in constitutional law, do you believe that there are many provisions in the Constitution, 1987 Constitution, that need amendments or revision?
Yes, I do.
Do you agree to the convening of a constituent assembly to amend the Constitution instead of a constitutional convention?
Well, Mr. Justice, I don't know, but I wrote a column on the matter last Saturday, and I proposed again a...
I'm sorry, I missed that.
So, it is again
I'm always reading your columns.
It was entitled Chartering Change, and I was saying that perhaps we can have a hybrid mode. This is like it will use the Constituent Assembly provision, but Congress will not convene unless and until there is already a buy-in on the specific amendments that will be passed. Meaning that they can only convene as a Constituent Assembly if they agree to amendments that had also been pre-cleared with the people. So in this mode, what I was trying to meet were the two objections of, number one, distrust, the issue of distrust with respect to Congress. With all due respect, Representative Tubas, but it would seem that the people are not very comfortable with Congress undertaking the amendments or revision of the Constitution because they're not sure what provisions will be amended. Second, there is also the issue of distraction. That I think this is the main issue of the President. That if we go through a constitutional change exercise, it might distract the country from the pressing matters that it is currently trying to undertake. So my suggestion was, let a non-governmental private sector group convene itself, come up with these amendments. It's not very difficult. There have been so many studies that have already been made. Come up with a document. They should consult with the stakeholders, consult with government as well, and then come up with amendments that people can agree on. And then meet with the leadership of Congress and tell them, okay, these are amendments that we can support. And at that time, perhaps the leadership of Congress can agree. Then they can constitute the Constituent Assembly. And then they can pass these amendments, hopefully in time for the 2013 congressional elections, so that we don't have to spend for the plebiscite.
Suppose it is decided that it be a Constituent Assembly to amend or revise the Constitution. Will it be with the Senate and the House voting separately or jointly?
Well, Mr. Justice, as we know, again, that is one of the editorial lapses that happened in the 1987
Correct.
Constitution.
Correct.
And Representative Tupas is fully aware of these lapses. No? If you ask me, I think that the more prudent interpretation would be that they should vote separately, because that will go hand in hand with the other provisions in the Constitution. If I'm not mistaken, there is only one provision which calls for both houses voting jointly, and that's in Article 7, Section 18, I think, in respect of martial law. So it would seem that the intent of the framers is to have a separate voting. But once again, this is one of those editorial lapses that we should amend, so that no more issues in respect of who will get to sit in the JBC will need to be addressed in the future.
In other words, you agree with Father Bernas that in order to solve the problem, the amendment should first be taken up by the House and later to be approved by the Senate.
Not necessarily.
Would that be feasible?
Not necessarily, Justice, in the sense that I think both houses, both the House of Representatives and the House of the Senate, should take it up independently, but not necessarily the House first and then the Senate. They can take it up together.
No, Dean, let's go to a subject which is nearer home, closer to home. The City of Manila Ordinance Number the City of Manila Ordinance Number 8027 reclassified parts of Pandacan from industrial to commercial zones, thus mandating that Filipinas Shell, Chevron, and Petron to transfer their operations elsewhere. The Those opposing the transfer argue that the transfer would disrupt oil supply and cause an increase in oil prices. The Pandacan Oil Depot supplies 1/2 of the country's fuel demand and 100% of lubricant requirements. The transfer would result in the loss of jobs of hundreds of thousands, not only the big three, but also of Unilever, Finco, etc., which would have been forced to move out of the city. The city of Manila would lose 66 million yearly in revenue if the transfer is pursued. Yet those who want the transfer argue that the oil depot poses a danger to life and limb and the safety and health of Manila residents. It might cause a disaster and devastation, a devastation worse than that of Typhoon Sindong, caused by Typhoon Sindong. By the time you reach the position of Chief Justice of the Supreme Court, if and when you will be appointed, the issues involved here will still be ripe for discussion and resolution. What are your thoughts on the matter?
Before you answer that, Dean, may just remind Justice Hermosissima, sir, that will be your last question. Your time is up. That will be your last question, or you're going to ask another question after the answer of Dean Bautista?
Well, I hope you'll give me more time.
We'll just allow you another question after this, after the answer of Dean Bautista.
If that's your wish.
Go ahead then. I'm sorry, you got, and then you go now answer the question of the justice.
Although with that question, Justice, I really feel like now a law student being asked to recite. Wala po bang multiple choice? A, B, C? No, seriously though, this is a multifaceted problem. As we know, it's not just legal issues that are in play, but there are also financial and economic implications. There are employment, livelihood, opportunities that also must be taken into account. These are the things that I think that the Supreme Court should really consult with other stakeholders whenever they make decisions in respect of matters of paramount or transcendental importance. And here, if I may add, this is where I think I have a bit of disagreement. No? In respect of the power of the court to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been grave abuse of discretion amounting to lack or excessive jurisdiction on the part of any branch or instrumentality of government. This is Article 8, Section 1. I think that the court has swung too much on the other side. That during the time of President Marcos, the complaint was the court was too timid, was too deferential to the executive. I think though after this provision was inserted by Chief Justice Concepcion in the 87 Constitution, the court has become too aggressive, has been intruding in matters over which it probably does not have the necessary expertise. So if you ask me, I think that the court should strike a right balance. Again, that the political question doctrine is still alive. As far as I'm concerned, there are certain matters that are best left to other agencies of government. That is the kind of philosophy that I would expound. And if you ask me, I think we should amend Article 8, Section 1. We should take out that grave abuse power and just bring it back to the original, because that alone gives the court already the important power of judicial review, and hopefully send a signal to the court that it will be able to re-examine its role within our constitutional framework.
I was hoping you will answer my question.
Well, my answer, Again,
you answered it indirectly.
yes, Mr. Justice, as I said, the problem is that there are many factors and variables that you really have to study in the situation that you had mentioned. I think that it would be difficult for me to give you a off-the-hip gut feel answer. I think, though, that as you had pointed out, these issues should be reviewed, and that we should speak and consult with the other players so that we can come up with an informed judgment regarding the case.
Last question, Justice.
The tremendous inherent power in the hands of the Chief Justice and the Associate Justice of the Supreme Court require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence, because the administration of justice is a sacred task entrusted only to individuals with the highest degree of competence. A judicial post is a position of honor and is offered only to those who are best qualified. Considering this, if you are appointed Chief Justice of the Supreme Court, what would be your judicial philosophy?
Well, I think I had provided a bit of a preview of that philosophy. As I said, I think that the court should rethink its role in light of the constitutional framework, as well as also in light of the current needs of society. That, again, for our tripartite separation of powers system to work, the court has to protect its independence, but at the same time realize that it is interdependent with that of the other branches, for so long as we are all promoting the common good. So I wouldn't say, when they say that the court is the least powerful of the branches, as we all know now because of Article 8, Section 1, that is probably not so. But on the other hand, I will not also say that the Supreme Court is the most powerful, because the executive continues to have the power to implement, and Congress has the power to appropriate. So I think that what we need to strike is a healthy balance among these three branches. I've also stated earlier that I felt that the court has become too activist in the way that it decides cases. I think that they should step back a bit, okay, and allow the elected representatives, directly elected representatives of the executive and the legislative branch, to craft the policy.
Dean, can you shorten that? You see, when you enter the portals of the Supreme Court of the United States, you will find emblazoned the words equality under law. That maybe is the judicial philosophy of the Supreme Court. Well, here in the Supreme Court, what do we say? Batas, Bayan.
Okay.
Do you agree with the motto of the Integrated Bar of the Philippines, which says, no master but law, no guide but conscience, no aim but justice? Do you abide by that motto?
It is a beautiful motto, Justice.
Okay, is that all, sir?
But can I also give you the one which is again very beautiful, also in the U.S. court? Fiat justitia rua caelum. Let justice be done, though the heavens may fall.
Okay.
So, in short, what is your judicial philosophy?
Not the long-winded one.
Do what is right.
Okay. That's all, sir? Justice? Okay. Now, upon request of Congressman Tupas, Secretary Mosngim, you will first ask the questions before Congressman Tupas.
I get my water, Mr.
I thought you want to sit already.
Okay na, nandito na eh.
Okay, go ahead.
Yes, Mr. Chairman, thank you very much. For anything else, I'd like to disclose, of course, that Andy Bautista is a former batchmate of mine in the graduating class of 1986 at the Ateneo de Manila College of Arts and Sciences. He is also a former classmate of mine at the Ateneo School of Law, and is, of course, a personal friend. Magandang umaga, Dean Andy.
Magandang umaga po, classmate.
Much of my questions, Mr. Chairman, has already been previously asked by some of the members of the panel. So I have reduced my other questions to about 3 or 4. Dean Andy, ano sa tingin mo ang halaga at responsibilidad ng punong maestrado at ng hudikatura sa ikauunlad at ikaaangat ng buhay ng bawat maralitang Pilipino sa ating bansa?
Sa akin pong palagay, and perhaps this is part and parcel nga of my judicial philosophy. Again, I think na ang ating batas dapat merong preferential option for the poor, the marginalized, and the underprivileged. I think this goes hand in hand with that shibboleth popularized during the time of President Ramon Magsaysay, na those who have less in life should have more in law. And why does this make sense? Because in reality, those who have more in life have less need of the law because they are able to get their rights protected on their own. Kung kaya't sa akin pong palagay, dapat meron tayong bias para nga sa mga mahihirap, para sa mga mararita. Pero wag din nating hahayaang inaabuso ang kanilang mga karapatan o yung kapangyarihang binibigay sa kanila. For example, yun na lang sa pagwewelga. Okay? Yan ay isang mahalagang karapatan. Pero again, pwedeng abusuhin. So sa aking palagay, importante na naman ay balansyado. Dapat merong balance. On the one hand, there is the police power of the state. On the other hand, there are the individual rights of the citizens. We need to create a healthy balance between the two.
Maraming salamat. Sa pangtanong, you earlier characterized the judicial system as inadequate, that it is inefficient, it's a bit broken. These seems to be very negative observations. I will deem it that you have constructively criticized the system as it is right now. But could you, however, cite reforms, if you know of any, that are being implemented by the judiciary under the previous Chief Justices that are worth continuing to be implemented should you be appointed Chief Justice?
If that was the impression, Mr. Undersecretary, I wish to correct that impression in a sense that, yes, I believe that the system is broken. But on the other hand, there have been several good projects that have been undertaken by past Chief Justices. For example, I think we should encourage the continuing use of court-annexed mediation. I think that if you look at the figures, it has shown that it has successfully diverted certain cases so that they no longer join the docket but are resolved outside of the court system. There is also JDR, Judicial Dispute Resolution, which again, the judge takes a more proactive role in trying to settle disputes. The creation of small claims courts is something that we should also look at. ADR, Alternative Dispute Resolution, and in fact in Singapore now they have ODR, Online Dispute Resolution, which would allow parties to settle their disputes through the internet. Again, there have been several projects that have been undertaken towards trying to clean up our system. But really my frustration lies in the fact that, as I said, there was that mandate in the 1987 Constitution 25 years later, that mandate has not been fulfilled. I look at other countries. You know, this problem of backlog has been faced by other countries. It was faced by Singapore in the early 90s, but look at their system now. It's world class. They were able to find a solution to these problems. So as far as I'm concerned, perhaps this was my youthful exuberance expressing frustration. But I also would like to think that perhaps it's about time that we solve these problems once and for all.
Can we go back to the point of you being an outsider applicant? Just to phrase this one, on July 16, 2012, the IBP conducted the first ever public forum in search of the next Chief Justice. And former Supreme Court Justice Maria Alicia Austria Martinez believed that it will take time before an outsider gets to understand and appreciate the judiciary as well. As an outsider, Dean Bautista, do you believe that you have a distinct disadvantage if you become Chief Justice, since it will require a longer time for adjustment than those you have that could have been appointed from the inside? If not, can you convince us that an outsider like you, without judicial experience, would be able to accomplish your role as Chief Justice, pursue judicial reforms, and administer, of course, the judiciary in the most efficient fashion?
To answer that question, Undersecretary Muskie, I think that the question all of us need to ask is that, are we happy with the way things are? Because if we're happy, then we should have more of the same. And I think that is where I am coming from, that there has to be a recognition that there is a problem, in which case perhaps we need a radical, out-of-the-box solution. Bringing in an outsider will hopefully provide new ideas, new perspectives, new insights in the way the court can function. As I said, we can bring in initiatives, not only from other countries, but also from the private sector to help in the system. As I said, part of the problem, I think, is that the courts of the past have been reluctant to accept constructive criticism. They have been reluctant to work with other stakeholders. I think that has to be changed. As I said, things are changing. We look at the 1987 Constitution. When that was passed, at that time, there was no cell phone, no internet, cable. There were only 5 channels, I think. 25 years later, our lives have changed. I think that the court should also change hand in hand with what is going on in society. So, to my mind, an outsider can provide a breath of fresh air into the workings of the court.
Dean Andy, how many cases are pending before the Supreme Court for or in behalf, for or in against the PCGG, do you think?
65 po.
And how do you think that you will maintain your integrity, your probity and independence as a PCGG commissioner right now and after you become Chief Justice, God willing?
I will inhibit po from the PCGG cases.
Do you think that matter of inhibition is sufficient to address judicial independence then?
Well, to be honest though, I would think, okay, that just because I was PCGG chairman should not automatically mean that I should inhibit. But again, if you look at it, and so as to dispel any doubts or to dispel any accusations of partiality, perhaps the more prudent action would be to inhibit if and when those cases are heard.
One final question, Mr. Chairman. You mentioned that during the Marcos administration, the court was timid. However, now that it has become aggressive, and sort of an activist. Could you cite at least 3 decided cases where you think that the Supreme Court has overreached and perhaps violated the political question doctrine?
Top on my list is the Manila Prince Hotel case, wherein a Malaysian investor won the bid in a closed bidding, but the Supreme Court overruled the bidding and awarded the case to a Filipino group, saying that, again, apparently under the Constitution, in terms of properties that have a national or historical significance, that these should belong, that they form part of the national patrimony and therefore should belong to Filipinos. Of course, we all know that even if Malaysians own the Manila Hotel, they cannot bring Manila Hotel out of the Philippines. Second, there was that case of Garcia versus Board of Investments. Okay, this is a case involving a petrochemical plant, wherein the investor wanted to move their investment from Bataan to Batangas. But the governor of Bataan did not want such a move because it would impact the revenues of the province. The Supreme Court again interfered with the decision of the investor and allowed granted the petition of the province of Bataan and therefore was able to stop this investment from happening, in which case, instead of the Philippines being able to attract that investment, this investment went elsewhere. And again, also with respect to some of the political cases, for example, the case of Estrada versus Arroyo, I wouldn't have decided it that way, in the sense that that to me was a classic political question doctrine case. Why are we going to force the issue as to whether or not President Estrada resigned? To my mind, as far as I'm concerned, at that point in time when the court was called to make that decision, he was no longer in power. The cabinet already had abandoned him. The diplomatic corps already recognized a new president. Why does it have to be that the court has to go and sort of like decide on merits and sort of like try to argue that there was indeed a resignation when the person himself said, no, I did not resign? So there are certain cases wherein I think it is better if the Supreme Court should take a back step and just allow things to happen as they are. They should not see themselves as the solvers of all the nation's problems, because that is not the case. And as I said also, I think they have to recognize their role, given that, again, within the scheme of things in a democracy, elected representatives are of a higher status than unelected representatives.
And that will be all for the aspirant, Mr. Chairman. Thank you, Andy. Good luck.
Okay. Thank you also, Secretary. Now, Congressman Tupas will now have the floor.
Thank you very much, Mr. Presiding Officer, Justice Peralta. Good morning, Dean Andy.
Good morning.
Kanina natanong na yung gusto ko itanong yung age, diba? Kasi nakikita ko dito 48 years old. Lang kayo po, no? Batang-bata.
Pero mas bata po kayo sa akin.
Mas bata ako. Pero kanina nasagot nyo na raw, ang sagot nyo ay age doesn't matter. Diba?
At saka ang sinabi ko rin po, dapat may term limit. Pati sa judiciary. In the same way, may term limit sa executive at legislative, dapat may term limit na rin ang judiciary.
Meron nga 70 years old.
Hindi, ang sinasabi ko po, 7 and 70. You only serve, because if you look at our constitutional commissions, COA, Civil Service, COMELEC, 7 years, tama na po yun.
Pero hindi kasi mangyayari yun ngayon At this time, hindi mangyayari yung term limit pag ikaw yung ngayon, nagde-deliberate tayo. So, ang question ko lang.
Sinabi ko rin po, ako'y handang mag-sign ng waiver.
Ilang tao? 7 years lang?
7 years lang, tama na po yun.
Okay. Pero 7 years, matagal rin yun, Kasi considering na may mga justices tayo incumbent ngayon, na 2 years na lang magre-retire sila. Diba? Yung iba 4 years. At tinatanong ko lang ito because I think para sa akin, siguro yung ibang members din, parang naging open ngayon yung proseso sa outsider. Ngayon, meron na pagkakataon yung outsider. For a long time, parang seniority yung tinitingnan. Pero because of anong nangyari, tinitingnan na rin ngayon yung outsider. At least ako, tinitingnan ko yon. So, yung age naman na 48 years old, kahit pagpalagay natin 7 years mag-waiver, mag-sign ho kayo ng waiver, assuming na gagawin nyo yun, matagal pa rin ho yun. At mababypass yung iilan. Kasi alam naman natin eh. And I am sure, tao lang naman yung mga ito eh. Di ba may pangarap rin at saka ang iba naman gusto rin mag-Chief Justice kasi gusto rin makatulong sa ating bayan. So, paano mo nakikita ito? Assuming na ikaw nga yung appoint, no? And youngest Chief Justice. And kahit hindi 22 years kayo mag-serve, pero 7 years lang. Paano nyo i-unify yung Korte Suprema? Especially yung mga senior doon na yung masasapawan sila. So, yun lang. Very short. I just need very short answer to that.
Well, tama po yun. No? At sinabi ko nga kanina po na sa aking palagay, all things being equal, dapat insider over outsider. Except that we are in a peculiar situation. Alam niyo po kasi nga, kung ikaw papasok, at nangyari na po ito sa aking mga ibang naging trabaho, kumbaga, kailangan nga medyo sensitive ka sa mga gantong klaseng issue. So you really have to earn the trust and the respect of these people. Pero dapat din po nilang ma-realize na kumbaga meron tayong constitutional framework at meron tayong rules and regulations. Kung itong taong ito ang nahirang ng Pangulo dahil sa listahang naibigay ng JPC, kailangan po yung respetuhin.
At tingin mo may unify mo rin pa rin yung... Kasi what we need now is yung parang figure na may status na stature na mag-unify ng Korte Suprema. Tingin mo ikaw yun?
Well, sa akin po palagay na kaya po, no? As long as people, I think, are professional in the way they deal with things, as long as people, again, look at the big picture and the collective interest of the common good, there should be no problem.
Okay. Pangalawang question ko. Balikan natin yung nangyari kasi kung wala naman yung impeachment, wala tayo dito ngayon at hindi ka rin aplikante, no? Hindi ka mabibigyan ng pagkakataon. Yung prosesong yun, tingin mo healthy yun personally? Healthy yun sa hudikatura?
Opo.
Bakit?
Kasi nga po, I think that focuses, nasabi ko rin kanina, no? Sa akin palagay po, yung impeachment ni Chief Justice was not just an impeachment of a person, but the impeachment of the system. Na, kumbaga talagang kung magtatanong ka sa mga karaniwang tao, meron silang pag-aalinlangan laban sa ating sistema ng katarungan. Kung kaya talagang dapat magpasok ng reforma. Kaya sa akin palagay, yung pag-impeach sa kanya, unang hakbang lang yan. Marami pang dapat gawin.
So healthy yun sa sistema?
Healthy po yun.
Punta natin yung transparency. At saka yung degree of criticism, kasi kanina nabanggit nyo yun Kasi tayo lahat, mga abogado tayo, di ba? Yung Pangulo, for example, executive, kahit i-criticize natin ang todo-todo yan, okay lang, di ba? Elected yan. Kami naman sa Kongreso, binabanatan rin kami. Sobra-sobra rin, pero okay lang sa amin. Di ba? Pero pag criticize mo na, for example, yung korte, yung judge, or Korte Suprema, maraming kaso na nadidisbar ka, na kukontempt ka. No? So, parang sa ibang tao, hindi sa akin, sa ibang tao, parang sinasabi nila, yung sistemang ito ng the three branches of government, yung may tendency ng pag-autocratic, out of the three, yun pa yung hindi elected branch of government, but appointive. Because of the cases na nangyayari nga na to. Disbarment, konti lang, kaya yung iba takot diba? Marami talagang takot sa mag-criticize sa Korte Suprema. Kaya nga, noong una nga, di ba, kami lang yung kasama doon sa impeachment, wala namang talagang nag-risk doon So, pag ikaw na, for example, ang naging Chief Justice ng Korte Suprema, ano yung specific reform, no? Towards dun sa degree of criticism? Because, Republican system Di ba Republican tayo, representative yung tao? Sovereignty resides in the people and all government authority emanates from them. Hindi naman talaga dun pa rin pupunta At yung tao, may certain degree of criticism tayo, may transparency. Gusto ko lang, very, very briefly lang, ano yung specific mong naiisip na i-reform yung sistemang ito if you become Chief Justice?
Mr. Representative, the word that comes to mind is balance. We have again to strike the right balance. On the one hand, there are your rights of free expression. Okay? And I think these are sacred rights. In a democracy, these are the rights that fuel thought and innovation. On the other hand, though, there is also the right naman of the court to maintain its integrity, credibility, its authority to dispense justice. We have to strike a balance between the two.
Paano yan? Paano mo
I
gagawin?
think dapat yung criticism is constructive, hindi personalan. Yun ang nagiging problema minsan. Kaya for example nga, ako, sa aking mga column, as much as possible, ayokong yung mga tao, because to me, we should focus on issues as opposed to focusing on personalities. Itong mga desisyon na ginagawa, okay, tingnan na natin on the merits. Okay, on the issues being raised.
So, magiging mahabang pasensya mo, ibig sabihin.
Yes, I think
Pag
that
ikaw ang naging Chief Justice.
dapat lang.
Okay.
You know, in a democracy, dapat ganyan.
Okay, so last, siguro 2 questions na lang, Mr. Chairman. Yung, nabanggit mo yung expanded jurisdiction at parang hindi ka atas-ayon dun sa nangihimasok sometimes, sabi mo, ang Korte Suprema sa political questions na traditionally. Gusto ko lang tanungin sa'yo, di ba, nakalagay yung expanded jurisdiction, yung para section 8 paragraph 1 yung expanded jurisdiction, no, ng Korte Suprema. Tingnan nga natin, di ba nakalagay doon na yung grave abuse of discretion, di ba? Tapos let's say meron naman sa Constitution, on the same Constitution, nakalagay naman na sole judge. Like for example, yung House Electoral Tribunal, di ba? At yung Senate Electoral Tribunal. Di ba merong term yon sa Constitution na sila yung sole judge with respect to qualifications ng mga congressmen at senador. On the other hand, ito naman expanded jurisdiction. No? Section 1, paragraph 2, paragraph 1 or 2, but expanded jurisdiction. Nakalagay, parang ito naman general. No? Paano mo i-reconcile yun? Let's say, kasi ngayon, ako, nung nag-aaral ho tayo sa UP at ng law, yung kala namin yung sole, pag House Electoral Tribunal, siya talaga yung sole. Diba? Pero ngayon, because of, may mga cases na pumasok na yung Supreme Court. So very briefly lang, paano mo i-interpret or reconcile yun?
Well, ito nga po yung mga ehemplo ng mga parang inconsistencies ng ating saligang batas na dapat i-cure, no? Pero sa akin pong palagay, ang issue is it really a legal matter? No? Dito po sa aking palagay, even if nakalagay na sole, I think it is a matter that the court can take cognizance of because it pertains to legal issues.
So,
at I try to distinguish that from cases that have a lot of economic and financial.
No, ibig sabihin kahit sole yan, sole judge on qualifications of members, tapos pwede pumasok ang Korte Suprema.
Again, sabi nyo nga, dahil sa Article 8, Section 1, itong grave abuse, pursuant to Rule 65, they have the ultimate power to determine whether or not there has been grave abuse. And this is different from the power of judicial review. Kaya masasabi nyo po, yung Korte Suprema natin, mas malakas sa Korte Suprema ng Estados Unidos.
Okay, last question. Dahil dito sa impeachment ng dating Chief Justice, parang ang taas na ng standard, di ba? Kahit ngayon, dati hindi naman ito tiniterevise eh. Ngayon, terevise tayo. Yung tao, ibig sabihin, yung mamamayan tumututok, di ba, sa atin. Tumututok sa atin, sa lahat na to. At may pagbabago, di ba? Kanina, although hindi naman ako sang-ayon sa inyo, yung sinabi niyo yung Kongreso, na parang nag-aalang-langan yung tao sa Kongreso, no? Although ako, Constitutional Convention ako, hindi ako Constituent Assembly. Pero hindi ako sang-ayon sa sinabi niyo. Pero since nagbigay na rin kayo ng opinion niyo sa Kongreso, tatanungin na rin kita. Kahit alam namin yung impeachable, kami ang magde-decide, di ba, ang Kongreso. Dahil sa napakataas na standard, tingin mo ang plagiarism ba impeachable?
Mahirap pala dito, Justice.
Sabi mo kanina, estudyante ka eh.
Oh. You know, feeling ko nga, you know, being a aspirant, you are like a binibining Pilipinas contestant, a witness in a Senate hearing, and the lawyer in the impeachment trial all rolled into one.
Pero sagutin mo na.
Again, kasi po sa akin din naman palagay, okay, we have to take into account the circumstances in respect of the case, no? Na,
Kasi, per se,
okay.
plagiarism, nag-plagiarize ka. Per se, hindi, saka na natin pag-usapan pa yung ibang detalye.
Yes,
plagiarism itself.
We have to look at intent. We have to look at circumstances. Again, if you have to be very specific about the case that I think you are referring to, I would probably say that it is not, given the circumstances that I know about that case.
Okay. Thank you. Thank you, Mr. Chairman. Thank you, Dean.
Now it's my turn. No? Naniniwala ka rin naman, Dean Bautista, na yung kasalanan ng isa ay hindi kasalanan ng iba. We are clear on that.
Tama po yun. Parang po yung mga kasalanan ng ama, hindi po kasalanan ng mga anak.
Okay. Thank you. Now, you were talking about an anecdote. No? You asked 40 students of yours that, who would like to join the judiciary, who want to become judges, and you said that only 2 responded. And one said that he or he wants to be justice of the Supreme Court. Is that my daughter?
Hindi po.
It's not my daughter. Definitely not my daughter. Okay. He's a professor of my daughter in Ateneo. Now, I have another question. Particularly Article 12, Section 5, Paragraph 5, the rulemaking power of the Supreme Court.
Article 8.
Article 8, Section 5, Paragraph 5. The Supreme Court has the power to promulgate rules and regulations in the enforcement and protection of constitutional rights. And that they say that the Supreme Court has become aggressive also because of this provision, and it has become powerful because of this provision. Now, if there is charter change, you would like that this provision be surrendered and amended to exclude this particular provision if there is a constitutional change?
No, I don't, Justice. Because I think in the end, with respect to rules of procedure, with respect to the practice of law, the Supreme Court would still be in the best position to make those rules.
Okay.
Ako, ang aking feeling po dito is that the people who are on the ground should be empowered as much as possible because they know the problems. So, ang issue lang po dyan, and again, I think Father Bernas raised this before, yung bang poder or kapangyarihan ng ating Korte Suprema, is that concurrent with the power of Congress?
That was supposed to be my next question, if that is concurrent. Because my next question is this, no? There is a conflict between the authority of Congress to fix filing fees and other court fees with that of the provision of the Constitution, this particularly because the Constitution likewise allow the Supreme Court to promulgate rules in the practice of law. And therefore, it can fix the filing fees and other court fees. And in fact, those are provided for in Rule 141 of the Rules of Court. So if there is a law passed exempting a certain public institution in the payment of filing fees, and the Supreme Court insists that the power to exempt the filing of fee belongs to the Supreme Court, if you are not the Chief Justice, how will you resolve that?
Pagkaganon po, I think that Congress should be differential in so far as rules concerning practice, pleading, and procedure. Yes, there is nga that debate as to whether or not they have concurrent power. I think that although in fairness to Congress, they have not really passed any law that would try and go against that power of the court. And perhaps they also realize that in case they do that, baka matalo sila kasi the final say in respect of the interpretation of the Constitution lies with the court. So siguro pwede natin gawin, if we do go through a constitutional amendment, lagyan natin ng word solely. Solely has the power to promulgate rules regarding practice and procedure. Bibigay lang natin sa Supreme Court.
What about the rulemaking power of the Supreme Court? Is that not in conflict with Congress? For example, let us take the case of writ of amparo.
Yeah.
That writ of amparo actually is a product of the rulemaking power of the Supreme Court. In fact, some say that what Congress failed to do, the Supreme Court was able to do it. We resolved the problem of involuntary disappearances. Take that as an example. Supposing somebody will challenge the promulgation of the rule on writ of amparo, what will be your position?
Again, here, ang aking feeling is that insofar as it tries to implement this constitutional directive to promulgate rules regarding the enforcement of constitutional rights, kumbaga, sakto po yan sa isang probisyon sa ating saligang batas. In which case, sa aking palagay, maliwanag po.
So papayag ka ron.
Papayag po ako na yun.
Nandun pa rin.
Nasa Korte Suprema
Ang
po
hindi
yun.
mo pinapayagan, yung Section 1 of Article 8.
Yan.
Yung power of
yung
the court.
pangalawa.
Oh,
Hindi yung settle actual controversy.
Because that provision might tackle political issues, and political issues are not within the province of the Supreme Court.
Well, purely political, yes.
Yeah, that's correct. Okay.
That's right.
Now, you were also suggesting that in order to reduce the backlog of cases, there is a need to amend Article 8, Section 12, or Section 15, I think. 15. The periods required of the courts to promulgate their decisions. No? But are you aware that the Supreme Court now has promulgated rules of procedures that reduce the periods within which to promulgate cases? I cite you examples like the rule and summary procedure. It is only 1 month, whereas the Constitution provides that insofar as lower courts are concerned, they have 3 months. You have the rule of procedure for environmental law, where the Supreme Court promulgated rules that it needs only 1 month. No, the courts have to promulgate their decisions within a 1 month period. Now, also in intellectual property cases, we just promulgate the rules on intellectual property. We have likewise limited the period within which to promulgate within a period of 1 month. So do you think that there's still a need to amend Section 15 of Article 8? Anyway, there is a collateral provision unless reduced by the Supreme Court. How are you going to respond to that question?
Mr. Justice, first of all, I think these are all steps in the right direction. And we have to applaud and we have to encourage the Supreme Court in doing these kinds of rules. No? Pero ang aking pong punteriya dito talaga is that, kasi nga, dahil yung period is counted from the date of submission as opposed to the date of the filing. Tinitignan ko po yung mga kaso po ng PCGG. Karamihan po dito, final 1987, 25 years na, nakabinbin pa po sa mga korte. In fact, meron pong mga ibang kaso, hindi pa po nagsisimula yung trial.
But in these PCCG cases, if you go over the petitions that were filed in 87, you will find that there were a lot of petitions or motions to amend the complaints. The cause probably was not attributable to the courts. It might have been could be attributable to the petitioners themselves, the government, the OSG, and also the lawyers of the other parties. Because considering the number of defendants, the number of intervenors, the number of third-party complaints, and so on. You should not.
Tama po yan. Again, in fairness talaga nga, I'm not trying to single out, kumbaga, the court as the culprit. But what I'm saying is that the stakeholders, the participants in our justice system are there to blame. And it includes PCGG itself.
Yeah, that's correct. Yeah, the way I was observing you, when you were asked by Justice Hermosissima, your answers were tend to invite or to court the vote of Justice Purissima. when you were asked by Congressman Tupas, your answers were also intended to court the vote of Justice Tupas. Now that I'm propounding the question, you're trying to court the vote of the Supreme Court. Huh? Is my observation correct? So anyway, let's go to Rule 65. Let's go to Rule 65. According to you, Rule 65 is a culprit, is a cause of backlog. Are you aware that in 2007, I think, we amended Rule 65? We put a limit to the period as to when a petition for certiorari under Rule 65 be filed. Before it was within a reasonable time. Now we fixed the period at 60 days. And that if there is an application for a restraining order, and there is no restraining order that be issued within the 10-day period from the filing of the petition, then the lower court shall proceed with the case, even if the main petition is not yet resolved by the appellate court or the Supreme Court for that matter. Are you aware of that?
Yes, I am, Justice. And again, this is, I think, a step in the right direction.
Oh,
pero,
that's again,
pero sa aking palagay po,
that's another vote?
hindi, pero now I will lose the vote. Kasi po sa aking palagay, kulang pa eh.
Ako lang pa ba?
Kasi inaabuso po yung Rule 65. Alam mo, pagka yung maliit na motion, maliit na incident, i-appeal, interlocutory appeal, because of that, matatagal.
Yeah.
Alam niyo po, ang gusto ko sana like this, para pong sa tennis ngayon, hindi ba meron silang replay?
Tinignan mo na naman si Justice Hermos
Sisima
kasi he plays tennis.
Yun na nga po. Hindi ba meron sila ngayon po yung replay na you can question the decision of the umpire, I think 3 times only. But kailangan merong limit eh. Hindi pwedeng lahat ng incident pwede mong iakyat.
Yeah, but
you have to also choose.
You know what we are doing in the Supreme Court? If a new petition is filed before the Supreme Court, if it is Rule 60 or Rule 45, that means is a question of law and raises a question of fact, we can immediately dismiss the case on the ground that the questions raised are questions of fact. There is even no need of requiring the other party to comment. Yeah. Now, if it is a Rule 65 as a special civil action, a petition for certiorari, and there's really no ground for the issuance of a TRO, we can also dismiss the petition. And that's what I've been doing, Dean Andy. Are you aware of that?
Yes, in fact, we know you are the authority po in criminal procedure.
No.
At sana po magturo ulit kayo.
Ang problema, ayaw ng misis natin eh. So, okay, anyway, last question. No? This is an observation only of your comment on the Supreme Court has no work plans to speak of. I hope I did not get you correctly, no? Baka you might lose your vote. For your information, we have several committees, no, formed by the Supreme Court, and these committees are headed by a Supreme Court justice, no. You have a committee to undertake the study of how to resolve the backlog of cases in the lower courts. We have the Committee on Computerization undertaking the study as to whether we can computerize all courts, including the first-level courts. And I do not know if you read the speech of our Senior Justice Carpio, that computerization has been effective in the Court of Appeals, and we want to introduce the system in other courts. And then we have also the PMO, which is the Program Management Office that undertakes the management programs of the court, headed by Justice De Castro. And then we have also the Mother Rule Committee, what we call the committee that undertakes the revision of the rules of court, which we call the Bible of all courts. And we have several committees to undertake and to answer the concerns of like you. And we discuss them on a regular manner. What happened to the meetings conducted by the committees. And in fact, we invite members of the IBP to join us in the committees. We invite NGOs to join the committees. We invite our developmental partners. No, I think Attorney Masguera is here. He was one of the, I think he's in the audience. He used to be part of the ABA, I think. Yeah, that also helped the Supreme Court in this program. And I just want to tell you this, that this is what we are doing, you know, to improve the efficiency and effectiveness of the Supreme Court. Now,
sorry, Mr. Justice, if I can just say again, I am fully aware of these programs. I think these programs should be encouraged. Siguro ang dapat lang talaga, the court should communicate these matters more to the public.
Ang problema namin hindi kami kasi politician, with due respect to Congressman Tupas, hindi kami pwedeng mag-interview sa TV regardless of your physical appearance. Hindi po kami pwede.
Pero hindi naman po kailangan magpa-interview. Alam nyo, yung sa website, you know, there are so many social media now that are available. Meron naman po tayong press spokesman. You know, just update regularly the public on what the court is doing to try and fix the problems.
We have actually the PIO, but with limited resources. No, you can just imagine inside the court here, in the session room, we have to borrow the television equipment of Channel 4 so that you can be seen before the eyes of the public. And that is my last question, my last comment, dear Dean Andy. I think we are through so far as you are concerned.
Ay, maraming salamat po sa
maraming
sa
salamat
mga
din.
miyembro ng ating council. If I may just circle back to what I first said, no, that as far as I'm concerned, really, while choosing the next Chief Justice is very important, we should not lose sight of the larger objective, which is to overhaul our justice system. And also, one person cannot do the job. It is a complex problem. I wish that the court, the JBC, the key to me is forming a justice league or a group of legal avengers that can really go through and really slay this problem that are facing our judicial system. Maraming salamat po at magandang umaga.
Maraming salamat din.
Ating pong natunghayan ang interview ng Judicial and Bar Council para sa unang nominado na nakaschedule na ma-interview ngayong araw. Ito ay si Chairman Bautista ng PCGG. At ang tema ng naging kanyang mga sagot dito sa interview sa kanya ay reforma at transparency sa Supreme Court at sa judicial system.
Si Chairman Bautista ay siya ring Law Dean ng College of Law ng Far Eastern University at nagsimulang medyo smooth naman yung kanyang interview. Nag-declare agad yung unang nagtanong na si IBP Representative Cayosa na meron nga po silang ugnayan itong meron silang magkakilala sila ng matagal na panahon at pati na rin si Honorable Musky, nagsabi na rin na magkaklase sila sa college and sa law school. Pero napansin natin that it was during the questioning of former Justice Hermosissima na nasukat itong kagalingan nito ni Attorney Bautista at kung whether he was talagang up to par ay magdedepende na yan sa iba din na magpapa-interview na at sa JBC mismo.
Mark, medyo naging napaka-technical at specific nitong pagtatanong ni retired Justice Hermosissima dito sa kay Bautista. Kaya medyo, I guess, yung mga non-lawyers mahihirapang intindihan kasi tungkol sa mga partikular na kaso. At tinatanong din niya yung stand ni Bautista tungkol dun sa transparency.
That's right.
Vis-a-vis naman dito sa sa ipinag-iiral na Korte Suprema na confidentiality dito sa mga kasong kanilang hinahandle.
Kasi nga ang isa sa mga katanungan din na lumabas or isang concern bago pa magsimula is whether we should get an outsider or an insider.
Yes.
So mukhang pinanindigan po ni Attorney Bautista, Dean Bautista, na siya bilang outsider. So talagang sinunod niya yung pagiging outsider by thinking out of the box, by coming up with suggestions kagaya ng ito, very radical yung kanyang suggestion, to outsource to the private sector yung docketing system ng korte na hindi na daw po gagawin ng korte yung mismong paglilista ng mga kaso at pagtatrack ng kaso kung hindi ibibigay na lamang sa private sector. So, yung kailangan timbangin yung transparency versus the need for confidentiality, transparency versus the need for a respectable distance na para hindi mabahiran yung mga huwes.
Isa rin sa anyay kanyang top priority kung sakasakaling siya ay mauupo bilang purong mahistrado, Ani Bautista, ay itong pag-hire ng, sabi nga niya, best and the brightest para daw sa judicial system. So, hindi natin alam kung paano niya gagawin ito dahil marami dito sa mga empleyado ay talagang mga plantilla positions
Tama
din.
At siguro marahil pwedeng sabihin ng mga taga-Korte Suprema na magagaling naman kami. Meron lang tayong pwedeng ayusin, dapat ayusin. Pero bilang nga, again, an outsider, he's coming from the mindset na kailangan pagandahin because there's something wrong. Sinabi nga niya, he summarized it when Congressman Tupas asked, sabi niya, siguro ang katanungan, are we happy? Pero siguro, yun kaya talaga ang katanungan, yung ating judgment pa of whether we're happy with the system or we want to give specific answers para ikaw ang magiging next Chief Justice.
Isa rin, Mark, dito sa mga sinasabing reforma ay ito nga pagbababilis nitong sistema ng pagdispensa ng hustisya sa ating mga kababayan na may mga kaso nga na ipinail dito sa ating hudikatura. At ito rin marahil ang gusto ng maraming tao. Matatandaan natin, Mark, na sa ating mga forum na isinagawa nitong nakalipas na 2 linggo, ay kaisa itong ating mga panauhin sa pagsasabing isa sa kailangan talagang reformang isagawa dito sa judicial system ay yung pagpapabilis ng pagdispensa ng hustisya.
Oo, siguro. In short, maayos naman si Dean Bautista pero medyo nahirapan siya, nag-struggle siya when he was asked specific answers for specific questions na medyo case-related or talaga masusukat ang kanyang wisdom. Maybe because he doesn't have experience as a judge. Hati, narito na ata yung pangalawang interviewee or aplikante para Chief Justice.
Ito ay si Attorney Soledad Cagampang de Castro, isang law professor. Pakinggan po natin.
From scratch. And so I have an idea of how a government office should work or ought to work, and how in private enterprise